All right. Good afternoon, everyone, and welcome to today's ADR talk. My name is Evelyn Kemani. I'm the acting CEO of the Chartered Institute of Arbitrators, and it's an absolute pleasure hosting you on this very, very important conversation. And we will actually just go right into the discussion. But just to give background information on why this particular conversation right now. At the beginning of the year, we had a peers lounge where we host a networking event for chartered arbitrators as well as fellows. And the theme of that event was on this issue that we're discussing today. And coming out of that discussion was, this is a conversation that we need to keep on having. And the reason for it is that we cannot overemphasize the need for ethics and integrity in our profession. So today we are joined by experts, arbitrators who have had years of experience, diverse backgrounds, and we are privileged to have retired Justice Joseph Nyamu with us, one of the past chairman of the Institute of Arbitrators. He brings with him judicial experience, many, many years of arbitrations, and we are really, really privileged to have him with us. We are also joined in by Advocate 𝐿 Mwihuri, who is a fellow of the Chartered Institute of Arbitrators. Wilson, I don't want to preempt the role of the moderator, but just to highlight the people who will be leading this conversation. We also have Mr. Patterson Kamaara, also another fellow of the Institute. We have Irene Kashindi, another fellow of the Institute, and they'll be deriving their conversations from experience, from what they have gathered over the years. And so today, as we're having this conversation, let's make it exactly that. Let's make it a conversation. Let us hear what your perspectives are, what your experiences are. And I know we will have an impactful conversation, we'll have an impactful way forward. And just to highlight this, the Institute is running its third edition of the State of ADR in Kenya research. And ethics and integrity is one of the areas that we're exploring in our research. So in between the conversation or in between the webinar, we will put up polls. We'd like you to assist us in that at how can we be part of the solution. We are taking into consideration your views. So without much ado, my role is just to welcome you. And I'll now take this moment to welcome our moderator, Ms. Irene Kashindi. Irene, fellow of the Institute, as I've indicated. She's a partner at MMK, based here in Nairobi. She's an employment lawyer, an employment law expert, and her CV is wide. So Irene, welcome and take it up. Asanteni.
Thank you so much, Evelyn, the CEO of the Institute, and thank you so much for having us this afternoon. I think it's a very timely discussion, and I'm happy to be the moderator of this session today. As Evelyn has said, we have a distinguished panel, and I could just, to save on time, I'll introduce them. I think Evelyn has already done a part of that, but I'll just give a little more details so that you can understand who is it that is appearing before us talking about a very important topic, which is lines that we must not cross, ethics and integrity in arbitration practice, a very timely discussion, as I said. Let me start by introducing, I think, someone that we all know, who is the retired Justice Joseph Gregory Nyamu, who is before he joined the bench, he was a practitioner for over 40 years in Hamilton, Harrison and Matthews, now at Denton's, Hamilton, Harrison and Matthews, where he practiced law. And I remember those early days when I joined HHM as well, and I used to see some of his paperwork that he had done previous years, and I would see the passion that he had even in arbitration during those early times. So after private practice, he joined the bench, where he served as the High Court judge, and a Court of Appeal judge, which was the apex court at that time. We didn't have the Supreme Court at the time he served, and so he served at the bench in those two levels. He's also served as a past chairman of the Institute. Just at the turn of the millennium, 1999 to 2002, he served as the chair of our institute. And of course, he is a fellow as well as a chartered arbitrator. And right now, he runs a firm that has a very unique name. It's called 𝐿. 𝐿 stands for Center for Arbitration, Mediation, and Legal Services. So it covers the whole gamut of ADR, arbitration, mediation, but also legal services. And he's also an author, and he has authored a couple of publications, including ADR in the Marketplace in 2018 and Raw Power, Supreme Court and Constitutions 2020, among others. Welcome so much, Justice Retired Nyamu, and we are really happy to have you today. Next, we have Mr. Peter Kamaara, as you had earlier on heard from Evelyn, who has been also in practice for quite a period of time, 43 years in private practice. He has mostly, practiced in the civil side of things. So he's done a lot of civil matters, but has also undertaken conveyancing and also some bit of criminal law. He did his first arbitration assignment in 1987. I don't want to say where I was at that point, but yes, he did his first assignment in arbitration in 1987 on an employment dispute. Quite interesting, because employment is really one of my key areas. I'll look for him to find out what exactly was happening in that case. He's been trained as a mediator in late 1990s from associate to member, but he's now a fellow from 2013. And he has been mentoring and training in arbitration and mediation space. And he's also an accredited mediator by both C.Arb and the judiciary. A very good welcome, Mr. Kamaara, and we are also very glad to have you. Last but not least, definitely, we have Wilson Mwihuri, who is an advocate of the High Court of Kenya and also a litigator, specializing in litigation, arbitration, dispute resolution, and he's currently a partner in Denton's, Hamilton, Harrison, and Matthews. And I'm your moderator, Irene Kashindi, as you heard. A fellow of the Chartered Institute of Arbitrators. I'm also specialized in dispute resolution, alternative dispute resolution, in several areas. I know I'm well known for employment, but I also do civil and commercial and other matters that are relevant to this space. So very good welcome, ladies and gentlemen. Our topic today, as you may have seen, is lines that we must not cross, integrity, and having Mr. Kamaara lay the bit of introduction and key principles that then underpin ethics. And so 10 floor is yours, Mr. Kamaara. Please take it up from there.
Thank you.
Before you do, sorry, I just want to put your questions in the Q&A tab. I believe there's a Q&A tab and also in the chat section, and we'll keep looking at it as we go along, and we'll also give you an opportunity to hear the responses to your questions towards the end. But please feel free to engage with us as we go along. Karibu sana, Mr. Kamaara.
Kashindi, I have been introduced in glowing terms. I hope I don't disappoint in the kind of presentation I'm going to make. What we're going to do to start off, I'll run through an introduction of what arbitration is. I am a tutor of the introductory course in the program, in the programs run by C.Arb. So, what is arbitration? I think you all know that parties choose to resolve the disputes in the hands of a neutral person, who we normally call them neutrals. And one of the key principles in arbitration is that this arbitrator, this neutral, is expected to be really neutral, to be impartial. Impartiality is a cardinal principle in arbitration. And as we go down, you're going to find out how impartial arbitrators have been. Ask yourself as we go down into the introduction of arbitration. Challenge yourself as to how impartial you can say you have been. Sometimes it's not human to be impartial. People tend to lean in favor of one person by a natural inclination. We are expected to be impartial because impartiality is what builds trust of the parties in the arbitrator. They get to be confident that they have the right person to determine their matter. So impartiality breeds confidence and the trust of the parties. A very important principle. The other principle is so hinging on impartiality is equality of parties. Expect for dispute resolution to treat well, allow them to ventilate their cases, give them equal opportunities to put forward their case. And in doing so, again, you build the trust and confidence, but also they go away with a feeling that there will be justice because the principles also of the administration of justice. Remember, we are administering justice in arbitration. Therefore, we have to deal with each party with equality. Equality of parties also means that I'm expected as an arbitrator to observe the rules of natural justice, which you know very well is the rule against bias, and it's also the rule that you must hear the other side. You must hear both sides or three sides, depends on the number of parties. So equality becomes a central pillar of the practice of arbitration. The other principle, which we cannot overlook, is the early stages in the arbitration courses. And we start by understanding that arbitration is a consensual process. Parties have agreed at the very beginning of their relationship or somewhere along the way that if any dispute arises, they would refer it to resolution by an arbitrator. So there is the power to arbitration. It is therefore important to know that the process, the parties are the one who chose God in the resolution of their dispute. For example, in the production of evidence, whether it's oral, documentary, or expert evidence, the parties have the powers to choose how to proceed with the hearing and determination of their dispute. And that is why in the Kenyan Act of 1995, most of the sections declare at the very beginning the words that unless otherwise agreed by the parties, that is really recognition of party economy. And in the 1996 Act, at Section 1, the definition of who an arbitrator is made, and one of the key pillars of their appointment is that they must allow parties to be autonomous and to decide how the dispute is to be resolved, a very cardinal principle of party autonomy. Remember always then that the process that we follow is a legal process. Therefore, we must not step out of the law. We must not do illegal things. Process from the start to the finish. So we must have some fidelity to the law, even though the parties have the so-called party autonomy. They have no permission to go outside the law or to force or to press the arbitrator to make an award that can be called an illegal award. Therefore, the legality of the legality or legitimacy of arbitration is a cardinal principle that we operate within the law. And this will be built in the contract. If, for example, you're dealing with a commercial contract, you will see that parties introduce an arbitration agreement in their contract, which talks about even the way the arbitrator is going to be appointed, again in exercise of their party autonomy, but also remaining in the legality of the contract to ensure that the process they have set out there is legal. It is not an illegal process. Legality of arbitration becomes another key principle. And talking about legality, we cannot forget the Constitution. It is the beginning and the end of what the people decided they should, how people decided to be governed. And one of the ways they said they want to be governed is by being allowed to take their disputes to ADR, to alternative dispute resolution mechanisms. So you'll find in Article 159 that the people donated judicial power to the courts and to the tribunals. But one of the guiding principles in the administration of justice is taking matters to alternative dispute resolution. And they're all listed there under subsection 2 of section 159, which includes mediation, reconciliation, adjudication, and of course, arbitration and mediation. They're all given there. So you'll be operating perfectly within the law to sit as an arbitrator because you are empowered to do so under this section. The other principle is about the confidentiality of the process. Parties could very well have gone to court, but they deliberately and consciously decided their disputes will be resolved through arbitration. And one of the advantages of arbitration is the confidential nature of the atmosphere. It is a confidential process. People don't want to wash their dirty linen in public just because they have a dispute. So the arbitrator is not at liberty, except where the parties agree to divulge information coming to him in the course of the arbitration, unless he is so authorized. It is private and not a public process. I am not around to go to brag to my fellow colleagues in the legal profession what kind of arbitration I'm doing between parties A and B. I must keep it into the confidentiality principle. One of the other critical values or principles is the principle of integrity. And I believe the whole of this research, which Irene has introduced, is about where is integrity in the arbitration process. And integrity is a cornerstone of the arbitration concept, without which we have no business saying we have an alternative dispute process called arbitration. An arbitrator must be honest. That is what integrity means. He must be beyond suspicion, high levels of integrity, high level of truthfulness. He or she must be truthful and must be trustworthy. He must be dependable. Under this principle, the character of the arbitrator, the character of the lawyers who appear before him, the character of the parties come into question. We must be men and women of integrity. And I dare say that the greatest threat we have to arbitration in Kenya and ADR in general is low integrity or lack of integrity. Under this heading of integrity comes matters like conflicts of interests. I'm, for example, a shareholder of a company which has brought their dispute into my hands for arbitration. And the reason it has been brought to me specifically is because the other shareholders know that I'm likely to render an award in their favor because I'm interested in the outcome of that arbitration. Without disclosing it at the earliest possible stage, and I allow myself to carry on with it and probably render an award naturally in favor of my company, I cannot be a judge in my own cause. The other side should know my connection with the company. I must offer at a very early stage to withdraw from the appointment and not wait for one side to say, oh, aren't you the holder of 50% shares in this company? I should have the integrity to declare my interests and, if possible, withdraw in order to retain the integrity and the impartiality of the process. So integrity would cover a very large item or sub-items, which in my mind are the ones we are calling the lines we must not cross. We have had murmurs about arbitrators being influenced or being bribed in order to render an award in favor of a party. That should never be said of an arbitrator. We have had even courts being accused of corruption. Whether true or not, it should never be said of any judge or any arbitrator that they are deciding a matter in which they have been influenced, in which they have been bribed or corrupted in whichever way. I know the country we live in today, that corruption is high, but we must protect our spaces, our arbitration spaces against this vice. Otherwise, we will have no arbitration or ADR to talk about. We shall not be corrupt. We shall not receive bribes, and we shall not offer bribes. When would an arbitrator offer a bribe? An arbitrator might offer a bribe so that he gets appointed as an arbitrator in a particular matter. Is that happening in our country or it is not? I would like to think it is not. I think during this research, we will be able to answer that question, whether there are instances where we have arbitrators offering bribes or gifts in order to be appointed arbitrators in certain panels, or even to be appointed as counsel in certain arbitration processes. Our integrity is the fulcrum on which the practice of arbitration turns. We must be completely above board and impartial. In an arbitrator, what we see is what we get. There's no halfway house around it. But before us, and as we consider this issue of integrity, and I'm sure we'll come to that later at a later stage, what about where you become aware, you as an arbitrator, that the contract that has been brought before you for adjudication was obtained or procured in corrupt ways? It's not obvious on the face of the contract document. You cannot read that so-and-so gave a bribe so that he won the tender in the tender process. But if you became aware that the contract, what the parties are not telling you, is the whole problem in front of you is a result of a corrupt practice in a certain place, how are you supposed to deal with it? Because you are not just supposed to be beyond reproach. You must be able to expose corrupt practices that come to your attention. This belongs to award. The award you're likely to give will be tainted with the corruption which played out at the contract performing stage. And you're going to be rendering an award which, if full facts had been brought to you, you would have known that this has some other underlying things which are illegal or unacceptable. You will come to that, I think, later in this webinar, where we might have to have some actual live cases where corruption has played out. Termination of some contracts is also done based on corruption. You are a contractor, you have been awarded a contract, but you have refused to play a certain game with the people awarding you. So, although you won the tender, somewhere in implementation, you refuse to play the ball of corruption, and your contract is terminated on other reasons, of course, not corruption. But the real reason is you refused to offer a bribe, or you had promised something which did not deliver on the sides. What am I supposed to do as an arbitrator when it becomes obvious that the termination of that contract was not because the work was not properly done, or there were delays in the performance of certain milestones? It was because there was not, the bribe promised was not given. How am I supposed to respond to that emerging issue? And it will not come in black and white. It will come through some nuances that you come through during the course of the arbitration. The other threats that we see in arbitration, quite apart from obvious corruption, you find reluctant parties, usually respondents, but I have had one or two cases of even claimants who seems to have changed their mind about the whole claim, and they are playing delaying tactics all over. And you find repeated applications for certain technical things, like asking for discovery of documents, asking for inspection of documents, and going back to the rules and saying if you don't discover and inspect within a given time, your pleading should be struck out. Then you find applications for striking out based on the fact that there was no full disclosure of certain documents, or they were not being able to inspect them. So you'll find lawyers, and lawyers here doesn't mean just the people studied in law, even other advocates who are not lawyers, they are valuers, they are architects who are representing parties and so on. You find them adopting a dilatory attitude, and you cannot help to see that they don't want this matter to proceed, at least not for now. And they're not forthright about it. And so they keep bringing frivolous applications. And what am I supposed to do as an arbitrator in that situation? Because I don't want to be seen to be playing along with the party who is delaying the process. My training is that I must deal with the speed. I must not delay the hearing, and I must render my award in a good time, in a reasonable time. What am I supposed to do? There may be no provisions in the Arbitration Act or even in our rules about what we have to do. But I was taught by Norman Mwihuri a long time ago that when you are determining a matter, you also bring your common sense with you. You don't just bring the book which says do or don't. You must have the sense of justice to know when the process is being abused. And you must respond in a way that does not, you don't seem to be playing along, and you're not conscious of the fact that time is going along. So you use certain tools like the peremptory orders, which we learned about, and in extreme cases, then you have to terminate if it's a claimant. If it is the respondent, you have to threaten to go on ex parte or go and actually go on ex parte because you can't wait forever. Other ways in which processes are delayed is where we find parties becoming just discourteous or just insolent and abusive of the process. And again, as arbitrator, in order to be shown that I am impartial and I am a man of integrity, I have to be firm about time, the time when things have to be done, and carry with it serious penalties. Like there is the other tool of using costs to punish the person who is delaying things. And it works, because if they pay costs a few times, they will feel, okay, let's look for another way of determining this matter because delay is not working. So those are some of the issues that I personally have seen in the course of arbitration, that you find there's a party who is deliberate about delaying, and then you find you have to be firm and make a decision. As I conclude, these values are very good on paper, but they are the ones that will make us see arbitration going on into the future. They are the ones that will enable us to bequeath to our children and grandchildren a vibrant space, a productive space of alternative dispute resolution. We are not the last generation. We shouldn't live as if we are the only ones who shall be arbitrators. We have children and grandchildren who look upon us to leave for them an inheritance of a process that resolves dispute. So we must sometimes be called to pay a price to protect this space. We must be ready to lose the jobs that we are being given. We must be able to go an extra mile so that we can preserve arbitration as a viable alternative dispute resolution mechanism. We must always all pay tribute to the people who brought down arbitration into our jurisdiction. I came in myself at a time of people like Norman Mururu, like Andan Marjan, like Mr. Thuo, Justice Kasanga Murwa, Justice Nyamu. They are people who fought really hard for this space. We didn't have the law. We had in our laws, we just, I think, had Order 49, I think, which had very limited, but now it has expanded. We have to know that it is these people of integrity who remained impartial and refused to be swayed by influences, external influences. And that is why we found a space where we are practicing our arbitration. It is our duty to behave like them and carry it forward. Now we have many people joining the institute and doing arbitration and ADR. That means we must be vigilant, because the more people we have, the more likelihood of infractions and breaking of the procedures. So we must set up very strict practice codes so that we remain in the narrow and deliver arbitration to the next generation. Irene, I think I have chewed up more than my time. And I would like to leave it there.
Yeah, you have, but I think it was very important what you've said, and maybe some of the things you want to cover them later, but we'll see whether you have anything in addition once Justice Nyamu comes in. But thank you for laying that introduction, for laying the basis, and for letting us know the underlying principles that inform integrity and ethical arbitration practice, and also just encouraging us to ensure that we be the torch bearers for the next generation, for this generation, so that we can have sustainability in this space. So our next speaker is Wilson Mwihuri, and just speaking from where Mr. Kamaara has left, he will take us through highlighting some key legal and professional framework that is applicable laws and standards. And why this is important at this stage is because we want to later discuss and know, why are these not working? Why are lines being crossed? And what can be done with either existing codes, applicable standards, to ensure that these lines are not being crossed, and if they are being crossed, what can be done in terms of enforcement. So, but before we get to the practicalities of it, we would like Wilson to give some top-level highlights of the legal and professional framework that's applicable law codes and standards that are relevant in integrity and in as far matters integrity and ethical arbitration practice. So over to you, Wilson, you have the floor.
Thank you, Irene. I think just following up from what Mr. Kamaara has said, I think I'll speak in broad terms just about the legal instruments, legislation, regulations that we may have on this particular subject. The list is by no means exhaustive, but I think what we will aim to do is just to demonstrate that the path that we're working on is not new. It's a very well-beaten path, and we're just trying to see what are the particular rules and regulations that we have on how ethics should be practiced in the field. I'll say a few words at the international level. If you just start from the international level, among the oldest rules that we have the 1987 IBA rules on ethics for international arbitrators. This is the International Bar Association rules. The introductory note is rather interesting, and if you allow me to just read what it says. It says international arbitrators should be impartial, independent, competent, diligent, and discreet. These rules seek to establish the manner in which these abstract qualities may be assessed in practice. But rather than rigid rules, they reflect internationally accepted guidelines developed by practicing lawyers from all continents. But importantly, what the guidelines say is that they will only attain the objectives if they are applied in good faith. So the takeaway here is that we may have guidelines, but if they're not applied in good faith, then I think they only just remain good on paper. Still at the international level, we have sometime in 2004, the IBA issued the IBA guidelines on conflict of interest in international arbitration. And the purpose of this particular guidelines was sometimes arbitrators and party representatives, they often unsure about the scope of their disclosure obligations. So what the guidelines on conflict of interest, they're not legal provisions, and they do not override any applicable national law. But the aim of these guidelines is to assist parties, practitioners, arbitrators in dealing with the important question of impartiality and independence. I think what Mr. Kamaara said is that sometimes you will be faced with a question which may not be so clear-cut. You may not be a particular shareholder in a certain company, but you're faced with a situation where you're really trying to understand, is this an issue of conflict? Should I disclose this particular issue? So if you can look for guidance in the IBA rules and IBA guidelines on conflict of interest, they help you because they have been developed over time. And in case of a party, an arbitrator, a party representative is unsure, it will help you to at least say this is where the disclosure obligation lies and what you can do as the arbitrator in that particular dispute. Lastly, on the international space, sometime in 2021, the International Council for Commercial Arbitration, ICA, they issued the guidelines on standards of practice in international arbitration. So allow me again to just read verbatim what it says, because I think it's important. It says, civility in the practice of law is an essential attribute of maintaining the rule of law. The guidelines originated from a concern that there have been repeated examples in international arbitration where practice of conduct that falls below the minimum civility standards, and the arbitration committee should take action in response to demonstrate our shared commitment to a fair and legitimate process. So even at the international level, it does not mean that just because a dispute is at the international level that standards are being maintained. What these guidelines seek to introduce is to say that there are certain, if you can call it, irreducible minimum standards of civility. Civility is how you interact with the tribunal, how you interact with the other party representative, how you interact with the parties, witnesses. It goes on to say that, for instance, guideline A talks about all participants shall act with integrity, respect, and civility to service other participants in the arbitral process. So these are guidelines we go to show you on, as much as we're talking about ethical lines, which should not be crossed, conflict of interest guidelines, but even the civility, how you carry out the arbitration yourself. As the practitioner, as the dispute resolver, as the arbitrator, there are certain minimum standards of civility that should be maintained. And I'm sure even Judge Nyamu will give us examples on, there was an example he was giving about a very senior advocate banging his table on a particular dispute because he's not happy with a ruling which went against him. So can that be said to be within the standards of civility? So that is just a very brief overview of guidelines at the international level. just to point out slightly, and if you happen to read these guidelines because they're available online, they're very clear that they do not override national law, national legislation. So if there are any national legislation or national guidelines on that particular issue, it is the national guidelines which will prevail. Now, bringing it closer home to the domestic level, the starting point, of course, would be the Constitution. If you look at Article 10 on national values and principles of governance, it says that the national values and principles of governance bind, and I think this is important, all persons, whenever any of them enacts, applies, or interprets any law. The definition here may be, it's mostly applied to judges and magistrates, but I think because there's some level of authority which tribunals, arbitrators have when you're deciding a dispute, which affects the rights and obligations of the parties which are before you, Article 10 actually binds you in how do you resolve that particular dispute. If you look at what Article 10 to the national values and principles of governance, it's an exhaustive list, but I'll just highlight it talks about equality, and we'll come to this a bit later in looking at the Arbitration Act. It says integrity, transparency, and accountability. These are the national values which should guide you when you are enacting, applying, or interpreting any law, which is what arbitrators do on a daily basis. As an example of, if you can just take an example of the national value of maybe transparency, practically as an arbitrator, when you're raising your fee note, you usually give a timesheet and indicate how many hours have you spent. And I say because I know the examples, even reported cases where certain arbitrators they are reluctant to provide a timesheet of how much time have they actually spent in a particular dispute. And when you raise your fee note and the party is objecting and you refuse, this is actually a real case where a party actually gone to court to compel the arbitrator to provide the timesheet. For whatever reason, the arbitrator refused, the matter went to court, became quite a heated battle. Eventually, the arbitrator was actually compelled, but now for whatever reason, they decided to challenge that decision. So it makes you question if you're really transparent in how you're deciding that particular dispute, if you are unwilling to even provide something which is as basic as a timesheet. And I say this because I'm sure those of us who are in practice, time padding has become a real issue where at the onset, you may think the arbitrator is quite reasonable, it's charging me a certain hourly rate. So you think this is going to be an affordable way of resolving this dispute. But by the time you get to the tail end, or even intermittently when they're issuing their interim fee notes, you're looking at the time and you can't really justify, you can't reconcile how much time the arbitrator is saying he has spent and how much time a reasonable person is resolving a dispute could actually take in such a manner. So these are the practical instances of, it's an issue of transparency, yes, also integrity for you as an arbitrator. If you're padding your timesheet, can you really be said to be living by the constitutional values that we have? So that is at the constitutional level. Then if we come to what the local legislation have, we have the Arbitration Act number 4 of 1995. I'm sure we all interacted with this particular piece of legislation. But having regard to the topic that we are discussing today, which is lines that must not be crossed. Sorry, if you look at Section 19 of the Act, it puts it in mandatory terms that parties are to be treated with equality, and each party be given a fair and reasonable opportunity to present its case. I think this is what Mr. Kamaara was talking about earlier. It's a principle, it's an ethical value, but it's also covered in statute in mandatory terms on how parties are supposed to be treated. You cannot be seen to be favoring one party at the expense of the other. You're giving more leeway to one party at the expense of the other. And also, if you look at the Section 19 is a duty towards the arbitrator, but Section 19A, it says that it requires the parties to do all things necessary for the proper and expeditious conduct of the arbitral proceedings. Mr. Kamaara has given us examples of parties filing application after application on discovery, inspection, whatever application they think may delay for whatever objective that they have. Can you actually say that, are you complying with the provisions of the 19A of the Act? Are you doing all things necessary for the proper and expeditious conduct of the arbitral proceedings? This provision actually imposes a duty on the parties not to engage in conduct which would delay the expeditious conduct of the arbitral proceeding. I think this was one of the attractiveness and what we've been taught in school and the trainings, that arbitration is fast way of resolving disputes. Actually, that's what that's what we are taught. But when you actually come to practice, you may realize that it's not as fast as you thought. Maybe because of all the dilatory tactics which parties have, for whatever reason, it may actually be lengthier than if you had gone to court. So failure to comply with what the mandatory provisions of Section 19 and 19A of the Act does, it lowers the confidence of the parties to choose this as a mode of resolving disputes. Because it's a why go for arbitration, and I've spent the same amount of time, I'd rather take my chances in court, where at the very least they have an opportunity to appeal or even review. So that is at the legislation level, where we have the Arbitration Act of number 9 of 1995. Then now, if we come closer down to the actual institutions which appoint and administer arbitrations in Kenya, the prominent one, of course, is the Nairobi Center for International Arbitration. It has a whole statute establishing it. It actually has a code of conduct which was issued in 2021, and Principle 2.7 of the Code of Conduct for Arbitrators says that the ethical obligations of an arbitrator begin upon appointment and continue throughout all stages of the proceedings. So at no point from appointment up to when you deliver the award, and even after, do you say that I have carried this load of ethical conduct for a long time, it's about time to put it down. No, it applies from appointment to the very end. And when you go through the NCIA Code of Conduct, if you look at principle number 7, it talks about termination on corruption, unlawful or illegal activities. It says that if the arbitrator is convicted by any court of law for corruption or any unlawful or illegal activities in relation to the code or any other agreement he may have with the NCIA shall be entitled to remove or disqualify the arbitrator at any time. So in my reading of this particular principle, it tries to give the NCIA some teeth so that its code of conduct is not merely on paper. It actually has some real life application and it can be enforced. It provides a deterrent. It's a deterrent towards arbitrators appointed through the NCIA, so that if you engage in certain behavior, you misbehave, maybe not even in relation to that particular arbitration, if you're misbehaving outside there and you are convicted of corruption or any other unlawful or illegal activity, you can actually be removed or disqualified. So at the very least, from what I can see, the NCIA Code of Conduct, it tries to ensure that there's compliance with its code and ensure that at the very least, the parties who remain on its were appointed through the NCIA, you can have some level of comfort that, to the best of their knowledge, the arbitrators have not engaged in such kind of conduct. Now, coming closer home to our distinguished organizer, the Chartered Institute, we have the Chartered Institute of Arbitrators Code of Professional Ethics and Ethical Conduct for members. This was issued sometime in 2009. It's published pursuant to the bylaws of the Institute, so that members may be reminded of the professional and moral principles which at all times govern their conduct. So the language of this particular provision is quite wide. It does not necessarily mean that whenever you're sitting as an arbitrator, that is when the bylaws and ethical conduct applies. Also, when you're maybe even sitting as a party representative, it is that word. As long as you're a member of the Institute, the Code of Professional and Ethical Conduct applies to you. It goes further to actually define what ethics means as moral principles or rules of conduct. So the code sets out a number of rules, the minimum standards of conduct that members should observe. And it says, importantly here, a significant breach of the code amounts to professional misconduct by virtue of bylaw 15.2. I'm sure you can read that in your own time what the bylaws provide. Then the bylaw, if you look at the bylaw, it says at Regulation 14 on supervision and discipline, it says the Board of Trustees shall establish by regulation processes and procedures for purposes of investigating any allegation of misconduct by a member and taking appropriate action, including imposition of sanctions. I must confess I was a bit puzzled, when I came across this particular provision, that investigations can be carried out and sanction imposed, not necessarily because the provision exists, but rather has it been enforced or applied. To the best of my knowledge and to the best of my research, I have not seen a situation where a particular arbitrator has been taken through this particular process of allegation of misconduct, whether they've been sanctioned or not. And I also say this because of a recent dispute I read in a newspaper not too long ago, where it's a dispute, it's a Kenyan dispute where there's a claimant and a respondent, where the respondent is a member of this particular institute. And when the arbitrator was being appointed, he didn't disclose certain fundamental facts that he had actually done work for the claimant. So when these issues arose during the course of arbitration, of course, the respondent says, please disqualify yourself, but the arbitrator refused. The respondent made a complaint to the appointing authority. The appointing authority said, there's nothing I can do. A complaint was made to the headquarters, the same reason, there's nothing we can do. So which is why I'm saying, as much as we may have the bylaws and the rules saying whatever they're saying, are they actually being implemented? We may have all these rules, but if they're not being implemented, there's no deterrent effect for other people in future continuing saying, if so and so did whatever they did, and nothing happened. What stops the next person or the generation which Mr. Kamaara is referring to? There's nothing stopping such unethical conduct if there's no enforcement of the rules that we have. Unfortunately, for this particular respondent, they tried to seek the intervention of the local courts, which really goes against the initial intention of trying to resolve it through arbitration, because when you go for arbitration, you're trying to avoid the courts as much as possible. But for this particular case, despite being presented with black and white evidence, irrefutable evidence that they had done work for the claimant, still insisting on proceeding with arbitration, demanding that the arbitration proceeds. So now the respondent has to seek refuge from the courts. I remember sometime when I was in school, and there was a certain lecturer, I will not name names, but he has a way of describing things in a very colorful language. He used to say that sometimes shame has a role to play in society, where there is certain, it keeps you in check, because you know if you do certain things, you may be ostracized in society, you may be not welcome to certain events. So it helps to keep you in check. But for this particular arbitrator in this particular dispute, the character had no shame whatsoever, insisting on proceeding despite being provided with irrefutable evidence that he had actually done work for the claimant. I dare say that this maybe the lack of shame maybe because there's no consequences. But I think this is an issue when we're coming to deal with reform. We may have all these codes of conduct saying whatever they're saying, but if there's no implementation, there's no enforcement, there are no repercussions, then the codes of conduct will remain just good on paper and of no use to anyone in the process. Lastly, on this particular issue, maybe sometime this is also maybe an issue for reform, when the confidentiality aspect of arbitration is that if an arbitrator misbehaves or breaches all these ethical rules, codes of conduct, his bad behavior and misconduct is usually contained within a very narrow, very narrow sphere. Maybe the persons who are involved in that particular dispute, maybe perhaps if you mention it to one or few of your colleagues. So the clerk, he may be emboldened to continue with such conduct because he knows in any event it will remain within a very small circle. It will not become common knowledge. So he may find, let me do whatever I want to do in this particular dispute. He'll still be appointed because that information is not common knowledge, and that in effect emboldens, actually empowers people to continue with such behavior. Lastly, regarding the legislation, and this is on the reform side, because we have the dispute resolution bill. I'm sure you have all seen the Chartered Institute sent us an email several weeks ago to comment on not only the dispute resolution bill, but other bills which are going through the process of public participation, just to try and modernize, if I can call it that, the law on arbitration. So if you look at the dispute resolution bill, it establishes a body called the National Dispute Resolution Council. And one of the functions of the National Dispute Resolution Council is the development of standards and enforcement of regulation. It also calls for the establishment of practice areas. For instance, we have the Arbitration Practice Committee. And one of the functions is to enhance the quality of ADR services through development and enforcement of tools of regulations and governance, including codes of conduct. So once again, we have a piece of legislation which is being discussed. It talks about codes of conduct, which we have seen there. There's nothing new. But to the best of my ability and from my reading of that particular bill, I've not seen any enforcement where you say that if you breach that particular code, maybe this is a discussion that can be pointed to them. We may have the codes of conduct, but without enforcement, without repercussions, without consequences, they just remain good on paper. For instance, it also talks about a code of practice referred to may include provision in relation to ethical standards and procedures to be followed by a party for redress in the event of dissatisfaction with the conduct of a dispute resolution practitioner. This is the best language that I've seen in terms of an attempt to have a process or a mechanism for enforcement. If the act goes through in the current language, we expect that procedures will be promulgated, maybe through rules or regulations, where a party can actually seek redress in the event of dissatisfaction with the code of with the conduct of a dispute resolution practitioner. Not the example I was given just a bit earlier about the respondent who was forced to complain to the appointing authority, to complain to the headquarters, to seek redress in court. If the dispute resolution bill passes in its current form and this provision is actually implemented, we expect to see that there shall be mechanisms for holding people to account, which I think is fundamental, because if there is no accountability, that particular conduct will continue. It also goes ahead to say that the council shall publish the codes of practice in the Kenya Gazette, which at the very least they'll have the force of law. So as I wind up, these particular provisions are timely, especially in the dispute resolution bill, in answering the questions all of us we have had. And I think this is even what the Institute is trying to look at in terms of the state of research and ADR. When there is misconduct, what do you do? Where do you go? How can you ensure that by the time you're a party representative, by the time you're an arbitrator, that particular process, the end product, is as a result of the evidence that is presented before the arbitrator and applicability of the relevant laws, with no other intervening or determining factor. Just the dispute is determined on the merits. I think that is why we're all here. That is why I think this particular topic is timely, and the lines we must not cross. I think Irene will allow me to stop it at that point. I think I've tried to lay a groundwork for the rules and regulations that we have, the legislation that is there. In terms of the reform agenda that is the bills that are actually being debated. Hopefully once they are passed, and then we can reconvene at another time to see, are they actually being implemented? Are they achieving the objective for which they were passed? Irene, I'll stop it for there. You can to continue the discussion. Thank you.
Thank you so much, Wilson, for a wonderful insight on the legal framework and the codes. And I've also seen what C.Arb has done in the chat section is to just post some of the instruments that you've talked about. For example, the IBA publications, the C.Arb code, and I think they have also added the terms of appointment of neutrals. So thank you, C.Arb, as well for sharing that with the participants. But also thank you once again, Wilson, for laying that basis, which of the applicable law and the framework that speak to ethical conduct and integrity in arbitration. Now that enables us to open the floor for Judge Emeritus, Justice retired Nyamu, so that he can then give bit of a deep dive and a deep analysis of the practicalities and reflections and realities of how ethical boundaries have really been breached, because Justice Nyamu, I think, is the best person to start us off in this section, because as Wilson said, that this is a well-beaten path. We have these codes and instruments, and I think he has witnessed these paths being beaten. And over to you, Justice Nyamu, so that you can then take us on our core segment, which is which we must not really cross, reflections and realities. And then we will wind up with a few comments later by the two other participants, then we'll open the floor for Q&A. But over to you, just Nyamu.
Thank you, Irene. Good afternoon, all.
Good afternoon, Judge. We can hear you. Yes, yeah, you can go ahead.
Thank you, moderator, and for the privilege to present the overview. I am short of material, substance, and context to present for 35 minutes. I pray that I am able to survive for 5 to 20 minutes. Luckily for me, I had in the form of a letter dated 12th of February 2025, addressed some of the practical problems touching on ethics in arbitration. I believe this has or will be distributed to all participants. The truth is, as far as the paper says, the line has indeed been crossed. And as the senior counsel, Kamaara, has indicated, there are real cases where the line has been crossed. But we need not give up. It is the future that lives. The starting point is to restate the objectives of arbitration, if I may. 1 is fairness, 2, cost effectiveness, and 3, speed. Second, I wish to emphasize the need for us to mold a culture of arbitration, which has focused on objectives of arbitration. By culture, I mean ideas, customs, and social behaviors of the arbitral community. To remain honest, faithful, and committed to the shared rules, laws, and practice pertaining to arbitration. And this way, if we focus on these objectives, we'll be able to avoid the cultures that are strangers to the objectives and purpose of arbitration. If I may particularize some of the problems, one of them is professional standards have gone down over the years. Advocates have generally fallen short of their craft, which can be attributed to lack of preparedness when they come to the arbitral tribunals, before arbitral tribunals, inadequate grasp of the law on arbitration and the governing law, and inability to innovate, because the future of arbitration is innovation. And the other one, which is a sticking, which is indeed a problem, relates to the issue of expertise. Advocates and others are accepting appointments without necessary qualification and skills. And this, in our kind of situation, is unfortunate because we have created over the years, I'm proud of this, having been involved in the initial stages of the training. We have over 600 members now, many qualified arbitrators, and therefore we have a vast pool from which parties can tap, can pick arbitrators from that rich pool. So it shouldn't be a problem to any arbitrator who is not qualified to turn down an appointment so that the next qualified person can be picked. The other practical problem, and I need not dwell on this, is the issue of integrity. Unethical, and what a past chairman of the institute called it, guerrilla practices, principally by advocates in order to obstruct, stall, and delay proceedings And this is why I'm talking about molding a culture of honesty and a community of arbitration that believes in these shared values. If you know that the purpose of arbitration, of coming to arbitration, is to attain fairness, to attain cost effectiveness, and to attain speed, why do you come with your gown and wig and start stalling the processes? The other area where many problems have arisen, as somebody has said, are costs. Both charging of costs and agreement on costs. But here again, I think we are very well guided by the Chartered Institute because they have come up with scales, which generally many arbitrators adopt. But that is not the end of the issue of costs. It's not just about the disagreements on quantum. Parties do refuse to pay, and this actually delays proceedings. This is one of the core practice. This is one of the areas where we have extensive delay because either one party refuses to pay, and because they want to stall. But talking about myself and how I handle this is that at the preliminary meeting, I agree the fees with the parties, and I craft a arbitrator remuneration agreement, where I provide that in the event, the responsibility to pay fees is on all the parties, but in the event of one party not paying, the other one could volunteer to pay. And the matter could proceed, because one of the areas arbitrators are allowed to stop the process is the non-payment of their fees. And obviously, advocates, knowing all representatives of the people, of the parties, knowing that that is one of the areas, can stall it. So that agreement, that provision in the agreement does cure this mischief, because you can proceed when the other party pays, and that you will probably not be accused of bias, because this is contractual. It is the tripartite agreement signed by the parties. Now, the other area of delay is court interventions in breach of the principle of party autonomy. And as we all know, Sections 10 and 32A of the current Arbitration Act really gives finality to the arbitral process. The idea was the interventions will only be done in accordance with the Act. For instance, under Section 35, setting aside an arbitral award on the grounds that have been set out in the section. There is no other ground upon which an arbitral award was supposed to be impeached. But what we have had in the past is that even before the ink really has dried on an arbitration, you find one of the lawyers has rushed to court to set it aside, mainly on the ground, the fertile ground for this is public policy. And public policy probably has not been sufficiently defined by our courts. I believe it's only one judge who made an attempt to define it as the breach of any written law in Kenya. But I dare to say that the international community has had a wider view of public policy. And I would appeal to our courts to adopt this. It includes any legitimate interest of the state. For instance, if a contract is about pornography or about child trafficking, that kind of thing, obviously, is not a legitimate interest. It is a legitimate interest of the state to stop that. So a court can intervene. And the public policy as defined internationally as international public policy, domestic public policy, are supposed to be, the international one is a bit lenient, because contrary to the findings of our courts, they say that the principle of finality is so important to the arbitral process that even if there is a mistake in the arbitration, they cannot upset an arbitration for that reason, if the procedure and everything has been followed, because there is a price to be paid for finality. It is a process that's supposed to regulate itself. Inherent in this process is the autonomy. Parties have by contract agreed even on the issue of finality. So why would the courts intervene other than the grounds set out specifically in the law? So we have had decisions, and I don't want to get personal because I have been on the bench myself, that have come out with the idea that because an arbitration award can be, for instance, faulted on legal grounds in one way or two, they must intervene. That is not public policy, as I have discussed it, and as we have seen from the other actors internationally. We, as a country and as courts, our courts, should move and adopt that wider view of what public policy is, where they want to intervene. Now, I know there are several decisions, about 3, that have been given by our top courts on this, and I know they are binding somehow. But what I would like to probably suggest as a practical way of dealing with them is to have them discussed by our universities, our professors of law, the law schools, and other stakeholders of arbitration. The other strategy could be to share platforms with the judges and present papers, for instance, in their colloquiums. We should find a way of linking up so that these things can be discussed, so that our judges are also abreast of the arbitration law, because it doesn't mean that when you are appointed a judge, you know arbitration. So I think we have the Chartered Institute should find a way of linking up with the Judicial Training School and present papers on this, so that in future the judges are able to review these decisions and are able to avoid this kind of pitfalls when applications are made. So we have to sensitize the judges, for instance, on the objectives and purpose of arbitrations as outlined earlier. The other strategy would be writing authoritative papers in the media, commenting on these judgments and so forth, not to annoy the judges, but obviously they don't have a monopoly of knowledge, and I think they accept that. I'm a judge and I'm aware of that limitation. These strategies, of course, are bound to yield results, but it is not an overnight thing. It will take time. Now, there are other concerns of integrity. That is, which I believe some have been hyped or exaggerated. Like, for instance, that arbitrators have been giving astronomical awards in terms of money. But surely, if you look at some of the contracts, for instance, in the construction industry, are in billions, millions, obviously, you will end up with an award in the billions. And that is not the fault of the arbitrator. It is because of the value of the contract under which the arbitration is being undertaken. The fact that some of these people are talking loudly about how arbitration has fallen into disfavor is actually not valid. It is actually a credit on the arbitral practice in Kenya that arbitrators are fairly independent, impartial, and they are fearless in coming up with what the contract provides, because arbitration is about doing contractual justice, doing justice in accordance with the contracts that the parties have entered into. You should not fear awarding whatever you think is just under the contract, just because people are talking about not incorporating arbitration clauses in contracts, because parties somehow have been told that we are expensive. If you look at that kind of criticism, where they say that arbitration is low and so forth, I mean, arbitration is expensive. When you look at it on the ground, that is not the position, because as we have discussed, arbitration has speed. It's supposed to be cost effectiveness as well, and it's supposed to be fair. If you come to arbitration, you actually attain finality within 6 to about a year, where an arbitrator is actually doing his work in accordance with the professional rules and so forth. If a trader or an entity, a business entity, gets an award within 6 months, 1 year of whatever amount, instead of 5 years or 10 years in court, then that kind of statement that arbitration is expensive flies away. It's not real, because he has his money faster, he can use it, circulate it, and it adds value to the economy. So I believe that side of the criticism is exaggerated, and it's not valid. Now, what is the way forward? Well, Senior Counsel Kamaara did talk about Article 159 of the Constitution as underpinning arbitration. But a closer look, as I have said in my paper, reveals that Article 159 only acknowledges or recognizes arbitration as a principle to be applied by the courts. There is no mention of arbitration as a parallel system to assist litigation. Currently, in my view, the underpinning of arbitration is under Article 1 on the sovereignty of the people, and Article 2, 5, and 6 on the general rules of international law and treaties or covenants ratified by Kenya. Kenya, for instance, has ratified a model law on arbitration. It signed the New York Convention many years ago, almost a few years after independence. So in a way, we cannot complain about underpinning, but in a future constitutional review, I think I would recommend that Article 159 be looked at fresh, so that the independence and the underpinning can be properly incorporated without any ambiguity whatsoever. On the way forward, I would like to focus on sanctions. which I believe Wilson has focused on, the law on the sanctions. When people fail, and they have failed, we have all failed, what mechanism exists to rectify that? That, I think, is the future. It's the future of arbitration, it's the future of arbitration as a subject that will continue to find favor with the people of Kenya. One of the inadequacies that has been there is the fact that, for instance, the Chartered Institute of Arbitrators have had the control of arbitration in terms of training and so forth. And obviously, we are part of the London office. And the Chartered Institute, the disciplinary powers, Mr. Mwihuri Wilson talked about a case which couldn't be enforced. It is because the power to enforce is vested in the head office. As a past chair, I had that problem of trying to deal with a disciplinary matter against a member who was trying to tout arbitration in a very awkward way outside the Hamilton statue, just next to the Supreme Court. I tried for many, many months to stop him, to persuade him that was not proper. When it failed, I tried London to enforce it, to enforce the proper ethics on the issue. They actually laughed at me and saying, I think he is doing the right thing. And so they are quite lax. But luckily now for the current chair, I think the future is rosy because of what Wilson had just intimated. We have the two acts coming up, the Arbitration Act Amendment Bill, which is, I think, in the public participation stage. We have the Dispute Resolution Bill, which is also at the participation stage. So my challenge is that the Chartered Institute of Arbitrators should take greater interest in the provisions of these two, because that is where the solution lies. For instance, the three cases that have been there on the intervention, constituting major interventions that have delayed arbitration in Kenya. These, I looked at the bill, and it has again provided expressly that the findings of what they have called an arbitral court will be final. There will be no other appeal at all. So the jurisprudence that has tended to delay arbitrations could be a thing of the past, depending on how the draft provisions finally, read. And it is my suggestion that the Chartered Institute should look at this very keenly, because I think it has also freed them from the London thing I have talked about, because as a matter of public policy, again, the government or the national, the Center for International Arbitration, which I think is under the Attorney General, has come up with this bill because they will be final on matters of discipline. But to give the matters of discipline, the provisions of discipline, the provisions in these draft bills, teeth, we must all participate, because they must be given the power to license and to debar members, to debar either counsel or even arbitrators. But as Wilson has said, if we just keep quiet, they will just come up with general provisions without teeth. And what we need are very sharp teeth to deal with past malpractices in this area. And finally, I would like to say that I am worried about one particular provision. I don't want to preempt the bills, but the way I have read it is that the council itself has come up with the obviously, you know, the act that set up the Nairobi Center also has a court, and that is the court that is intended to replace the court in the Arbitration Act and in all other areas. We should take very keen interest on the composition of that court, because we might maybe come from the frying pan and place ourselves into the real fire. We need to take interest in the independence of a court like that and its composition, its appointment, because, as you know, our courts are fairly independent under the Constitution. I see this as a watering down of, we may be happy about the finality of arbitral award. I think we should be very careful on whether we need something like that. I think, with your permission, I would like to end there, but maybe for the purposes of the audience, say that the National Dispute Resolution Council proposed under Section 6 has the powers, as Wilson said. The practice area committees under Section 14 of the bill establishes practice codes. It is these practice codes we should take interest in and insert the teeth to deal with the malpractices. Maybe one final remark on what has been bothering us, especially the participation of our courts and their interpretation of the provisions relating to arbitration. Under Section 35, the proposed amendment in the Arbitration Act states that appeal from an order for grant or refusal to set aside made by the High Court under Section 35 will in future have to be done with the leave of court. In other words, if you want to go to the Court of Appeal, you can't do that without leave under that section. This is very positive, and I think we should salute that, because it also takes care of the bad jurisprudence that we have had in the past. And do I now have your permission, Irene, to wind up?
Yes, Judge. Thank you so much for your insights. Thank you for taking us through the reflections and realities on how these ethical boundaries have been breached, and why the existing codes and institutional framework may not be working or may not be fully enforced, and what reforms would look like. Now, I know at this time we had planned that we would open the Q&A, but I know the other participants, Mr. Senior Kamaara and Wilson, had maybe a few things to add on this segment. But my suggestion is maybe you could add a bit of new nuances here and there in what you had planned to add in this segment when you're answering questions. I hope that is okay, and maybe in your final remarks to save on time, because at this point we were intending to start the Q&A. I hope that's okay with Senior Kamaara and Wilson. And then I could just read some questions posed to any of you, and then maybe you could take the liberty to add anything else that you think you wanted to add at this point. I hope that's okay. Maybe we could start with the very first question that is directed to Mr. Mwihuri, which was by Mr. Paul Ngotho, who is asking if you could give the citation of the case in which the arbitrator did not disclose that she had carried out some work. Of course, if it's a reported case, I think you can disclose, or if you're able to disclose it anyway, maybe you can disclose this to Mr. Ngotho. But I think there's a more substantive question that has been asked about the applicability of Article 50. I directed to you, Mr. Mwihuri, but I think either Justice Nyamu and even Mr. Kamaara can chime in when they take the floor. But this is, I know they've read it, Wilson, but I could just read it for the benefit of everyone else, by 𝐋𝐢𝐧𝐞𝐬. I hope I pronounced your name well, Isaac, that the point on confidentiality and transparency question and how transparency, publicity can act as a deterrent to ethical conduct in arbitral proceedings. It's time in Kenya to implement all aspects of Article 51 of the Constitution of Kenya 2010, including arbitral proceedings, just as court proceedings being public by default, with confidentiality, privacy permitted only in certain circumstances of Article 50, Article 8. Maybe a number of confidential arbitral awards need to be set aside on the public policy ground of non-compliance with Article 50 to restore the rule of law in the conduct of arbitral proceedings in compliance with Article 50. I think this is aligned to what you had said earlier on, Mwihuri, about the fact that maybe arbitrators could be taking advantage of the confidential nature of arbitration, such that if they are being unethical or breaching integrity or crossing integrity lines, they know that it will be kept under the cover of confidentiality. So maybe if you could take the floor to answer that, those two questions, then we can take up Mr. Kamaara coming next. Over to you.
Thank you. Yes, thank you for that, Irene and Mr. Luchera. I've read your question. I think because this is not a new area. There are quite a number of papers which have been written about confidentiality and transparency in arbitral awards, especially where one of the parties is a public body. So there's that discussion on why is a dispute involving a public body being decided in private. So there's a lot of discussion and a lot of research on whether disputes, not necessarily involving private parties, but involving public parties, should be decided, or even if it goes to arbitration, whether the outcome of that arbitration should be public. For private parties, because of the principle of party autonomy, if you decide to resolve your dispute in private, I think there's a constitutional underpinning where that is how you decide to determine your dispute. It's really that is a principle which has been upheld. It is a fundamental principle of arbitration, but doesn't mean to say that it cannot maybe change in the near future. But the reading that I've done so far and what I've come to see is that in terms of transparency and confidentiality, it relates more to disputes involving public parties, public entities, governments, parastatals, such parties, not necessarily all. So if we are trying to make the argument that all arbitration should be in the public domain, maybe that's food for thought. I can't really say that. I'm not a fortune teller. I can't see what the future will hold, but it is food for thought. Maybe just on this particular issue of the confidentiality, and the reason why I brought up that particular issue, there's a recent decision of the Court of Appeal of the Republic of Singapore. This is DJP and two others versus DJO and two others. So you can see even they're still maintaining the confidentiality of the parties, but deciding the dispute. So you don't, even if you read the judgment in its entirety, you can't really tell who the parties are, but because they're being referred to by the acronyms DJP and DJO, the confidentiality aspect remains, but the matter has actually gone to the Court of Appeal. And the issue in this particular matter, which went all the way to the Court of Appeal, was that the arbitrators in the award which led to an application to set aside in the High Court, which went all the way to the Court of Appeal, was that it was a panel of 3 arbitrators. The presiding arbitrator in that particular dispute had similar disputes involving one of the parties. So what they did, or what the presiding arbitrator did, is that out of the 451 paragraphs of the award which was being disputed, 212, let me say almost 50%, was a copy-paste from a previous award. So even what the Court of Appeal was saying, and if you can find it online, it raises the fundamental issues about an arbitrator's duty of independence and impartiality. Because if I'm copy-pasting more than 50% of my award from a previous award, have I really applied my mind to the evidence which the parties have presented before me? Have I applied my mind to the issues which are before me now? Or did I just take a shortcut and copy paste, do the award in the shortest time possible, get my fees and go on? And the only reason why this particular dispute, I think it got all the way, it raises question on how many, or is this practice endemic, or how often does this happen where you get an award, you can't really confirm whether this is the final product of the independent thought of this particular arbitrator, or did he just decide to, because he can say this is a contractual dispute, we all know the elements, he just transposes from a previous dispute to this one. So the issues of confidentiality and transparency, it is an ongoing discussion. There's a lot of articles, research that has been done, a recent one recently by my friend Emmanuel Etangula, which is available online, on whether there should actually be transparency in arbitral awards. You can still maintain confidentiality, especially in this age of very high-tech world that we live in. You can redact, you can actually reduction is more what applies, but you can maintain confidentiality of the parties, but transparency is still there. So I hope I've answered your question. It's an ongoing discussion. I don't think we can answer it today fully, but it is an issue worth discussing, especially in light of what we're trying to discuss in terms of ensuring that lines are not crossed. Because lines are usually crossed. I think there's a saying, I can't remember which particular newspaper, that democracy dies in darkness. So maybe we can say the same thing. An ethical conduct thrives also in darkness, because if you don't know what's going on, it will continue to persist. Yes, I think, Irene, I can leave it at that for you.
Yeah, thank you so much, Wilson. And I think when you were talking about that case from Singapore, where there is, clear copy pasting, I don't know whether I've not read the case, but I don't know whether it had also, an issue to do with, was that commensurate or proportionate to the costs or the timesheet that the arbitrators would present? Because if there's such a copy paste and then maybe so much hours are said to have been spent, then of course those are lines that should never really be crossed, right, Wilson?
They didn't go into the details about the issue of cost.
Okay.
The fundamental issue they were discussing is, you as the tribunal, have you really applied your mind to this particular dispute? Because out of 451 paragraphs, 212 have been copied. So did you really do any work here?
Yeah.
So and what are you saying in terms of resolving the dispute? Because the parties came to you to resolve a particular dispute in an independent manner by analyzing the evidence and applying the law. But if you just 50% of the award came from a previous award, then it brings into question the fundamental legitimacy of the process. Because if the process is not right, then surely the outcome, there's something terribly wrong. But it's a very interesting judgment, right?
All right. And maybe we could now move on to Mr. Kamaara before we then come back to the judge. And maybe, Mr. Kamaara, I could pick with you to maybe answer a related question that may arise from what just Wilson has talked about. AI use, artificial intelligence use, are those lines that we should also not be crossing, such that, if we are using AI in our work as arbitrators, what does that mean? Maybe you could do that as you pick the next question, which is from Angela. Angela talks about public policy in arbitration is a core legal principle that certain core values and interests of a state or society must not be violated, even in private dispute resolution process like arbitration. I think that was a comment, not a question, but there's a question here from Shafiq, who says arbitration is now the new litigation. Advocates immediately raise preliminary objections either for recusal or lack of jurisdiction just to derail the matter. I think you had touched on that earlier on, but please pick the AI question and then you can move on to this question from Angela and Shafiq, who are talking about that arbitration is really the new litigation. What do you have to say about those two questions?
Yes, I can feel them, if I can use the Gen Z language. I can feel where they are coming from, because when we started to go to arbitration, it's because we are getting bogged down in the courts. It was taking too long, a lot of technical procedures. And when we came out of arbitration, we came there because we were told one of the benefits of arbitration is flexibility and control of our own time. So things would happen within given timelines. But whether that is happening today or not, where people are saving on time and on costs, It's a matter that we can debate, like Justice Nyamu already touched on the issue of costs and how they are charged. And before I forget this point, we can never have a strong arbitration or ADR system if we do not have a strong judiciary. Judges are our partners in the administration of justice. They are not rivals, they are not competitors. We work together, and I like the idea Justice Nyamu has brought forward that C.Arb should find a way of finding the judges when they are relaxed in a colloquium and talk to them about the value of arbitration. A huge backlog of cases has been removed over the years because of the resolution through arbitration. So we must also work to ensure we have courts that work, because as you know, there are certain areas that are actually strong in support of arbitration when we come sometimes to appointments, sometimes to enforcement, sometimes to hearing when we require assistance from the court to do certain matters in evidence. So we cannot do without them. Then they have the coercive powers to force us to comply. Now you find us, we are going back, and that's why the question has arisen, that we started well, but we seem to be going back to the courts now. And people feeling, oh, we should have not left court in the first place. So you waste a year or two outside in arbitration. And then finally you find a lawyer coming robustly to say you have no jurisdiction or you have exceeded your jurisdiction, and they do go to court. The happy point here is that we have come a long way with our courts. There is a time that they were stalling in allowing arbitration to thrive, but with the time, I guess because quite a good number of judges are now trained in arbitration, they are arbitrators in their own rights, and they know why we only go to court for intervention on very limited situations. And we have had very good judges going out of their way to defend their awards and saying, you chose this process from the beginning, you must finish it there before you come to us for anything. So strong arbitration processes must be backed by a strong judicial process. And if we have corruption in the courts or irregularity in the court, it means it's a reflection perhaps of the entire society where we live. Corruption becoming a culture, the way Justice Nyamu said, what we are asking for now is like a cultural shift where people start accepting that corruption is an evil that we must fight everywhere we go. And so this shift must happen in our time. We must not allow the younger people who are coming behind us to come and inherit a stinking system where everything goes, everything is for sale, every arbitrator has a price, that kind of a thing happening. We must avoid that at all costs. We will not have business, maybe we will never get work because we didn't bribe, but probably it's a good price. It's a small price to pay for the growth of our chosen line of arbitration practice. So the courts must always intervene, but we must show character. We must show up as people who can stand against approaches of corruption. And I'm saying this because I have personally been on 2 occasions. A party has tried to reach me up with quite a handsome bribe, very tempting. Very, very tempting. And at a very critical stage of the proceedings, because those who give bribes know the time, the person, and the place where these things must happen. And when we have more time, I'll give details of what is, where they pass, where the money passes, and what the psychology behind you being approached. Some even work through stakeholders. And the message reaches you that if you rule this way, your money is with Mr. So-and-so, who is your friend or who is a stakeholder holding it for you. It's not a simple process. It's complicated. It's as complicated as arbitration itself. They go through friends and friends of friends to reach at you. And you must be available to stand up and say, no, no. And I can tell you that in one of them, it's a long time ago, I even don't remember the parties, I had already read out the award. It was waiting for payment of balances or fees, and then release it. That critical time, when it is well known you have read at the award, you are just waiting to publish it. That's the time they want to come. And that is the time when you have to be on your guard. The period just before you finalize your award. They won't come earlier because other things could intervene and then the award does not happen. They want to come at the critical moment. So you are being followed. When you are holding those preliminary meetings, when you are holding those hearings, the arm of corruption is everywhere in Kenya today. And we are not an exception. We live within this system. It will require sharp integrity for you to be able to say, no, we shall be objective. And if it persists, you pull out from that matter altogether. And you lose the money, you lose the work, but you go home and sleep well. So let's know that it starts with us. It starts with every individual arbitrator. The lawyers who come to stall the process, we must tell them very firmly, this is arbitration. Let the arbitration play out. Let us finish to the award level. If you're unhappy, you know what to do. But don't stall it at preliminary stages with applications about jurisdiction or about how the evidence is going to be led, where are the original documents, where is this and that. We must be able to see those things because these are the ones bringing disrepute into our arbitration space. And we must behave differently. I know in course the procedures and so on have to be followed. Timelines have to be followed. We must also try to have timelines when submissions have to be filed and when leave is required, so that party do not assume the arbitrator, because he is flexible, he can come months late to file their statement of claim or to file their responses, or they want to just stall the process by one reason or another. So what I want to emphasize are those 2 points: strong courts, strong arbitration process, personal character, and your ability to sniff it before it bites you. That is very important for us. Some of these things will never be codified. They will never be able to be, say, the do's and the don'ts and the penalties which are attendant to the consequences. But you as an individual, the way you were trained so hard in a very expensive program to become an arbitrator, you don't sell it out cheap. You don't sell it out with a bribe. Defend this territory. It belongs to us and our children, and we must keep it for them. Irene, enough.
Thank you so much, Senior, for those very insightful, contributions. It starts with us: personal character, ability to sniff these things before they bite us, the strength of the courts, and so on and so forth. When you were talking about it starts with us, I remembered my stint at the Public Procurement Administrative Review Board. I served representing LSK from 2020 to 2023. And before I joined, I was having a discussion with colleagues and just trying to learn how it is that the board works. And I think some of them were telling me, colleagues just in the profession, that this is a tribunal that handles very high, disputes about very, very, very valuable, high values. And I knew that because I'd appeared before the board before. And I think my colleagues were telling me that, the parties always try to compromise members of the board. And I served there for 3 years. No one ever, came to me, not that I wanted them to come to me to seek for any compromise, but no one came. And when I was discussing now with my colleagues when my term was ended, they said, some people discuss, people know in the field that, this is not a person that you should even try. So I think if your reputation precedes you, no one would even try. No one would even want to embarrass themselves But you can imagine now for you, Senior Kamaara, someone was trying to come to you and then you were telling them no. It would be very embarrassing, like what Wilson was saying. Shame also works. Like they are coming to you and you're not allowing that to happen. So yeah, I think our reputation should precede us. It might be a very tempting scenario that you may find yourself in, but I think you look at it from in the long haul. What do you want your legacy to be 20, 40 years down the line? Do you want to be remembered as that person who would easily be compromised? Or do you want your legacy to be, very strong and something that can speak for yourself? So I think that for me is a really good takeout for me personally, that it is really personal character. And I think we could take that as well as one of the key insights that we take out of this session. I know our time is almost running out in the next 10 minutes, but let me just try to highlight some of the questions that hopefully we can answer. And I wanted to now call upon Justice Nyamu to answer some of the questions here, where there's Angela Nyalita asking, we must be strict in terms of time taken in arbitration. Is it 60 days? Parties should then seek extension if they are out of time, just like we do in court and next mediation. And this question, actually, someone had asked me when they saw that I'm part of this panel today, and they had asked actually me to ask this question to the panelists. So let me ask also a bit of a different question. The person who was posing this question asked me, is it possible to frame the arbitration clause in such a manner that you limit time? You actually say this arbitration should be decided within 6 months or 1 year. If it's not decided within 1 year, then the arbitration clause ceases to be operative and parties can then decide to go to court. Is that something that maybe will deal with the issue of timelines, or will that be diluting the party autonomy principle? Maybe Justice Nyamu, you could answer that. But as you answer that, there's a second question that talks about Article 151, Article 13. So let me just read that question very quickly from Isaac. He says, Justice Nyamu, status of the arbitration in the Constitution, Article 13C provides that the sovereign people of Kenya have delegated their judicial power to both the judiciary and independent tribunals, which includes arbitral tribunals. Article 159(1) acknowledges that judicial authority is derived from people and is exercised by both courts and tribunals. Article 51 provides that it's a right of every person to have their dispute resolved before a court or another independent and impartial tribunal, including arbitral tribunals. My view, arbitral tribunals are already adequately provided for in the Constitution, being on par or at par with the courts, but subject to the High Court's supervisory jurisdiction under Article 165, 6 and 7. So Justice Nyamu, if you could answer the issue of time limits in arbitration, and also just maybe make a comment on what Isaac has said about the constitutional and opinion of arbitration. Over to you, Judge.
Thank you, Irene. I believe that kind of provision in a contract would obviously receive a lot of sympathy from the arbitral tribunal, and subject to the ability to meet the timelines, it will be a good gesture in terms of honoring the terms of the contract. But I believe the tribunal still reserves a discretion really to give the award within a reasonable time. And I think the tribunal would lean very heavily on the Act. And the Act does not give, except the Chartered Institute of Arbitrators rule do give indications on the 6 months she's talking about, that an award should be given within that time. Maybe to address that, that is why the Arbitration Act is being amended. The new Section 28A of the bill provides for fast-tracking of arbitrations. Maybe that is where the parties, that should be the area the parties should be, the provision the parties should be invoking for a quicker process. I think that's all I would say about that. I don't know what the second limb was. What?
It was just a comment. I don't think it was actually a question. Someone was agreeing with you on the underpinning on constitutional ADR arbitration underpinning under the Constitution referring to Article 1.3. I think it was just a comment, not necessarily a question. So I think in the interest of time, we could move on. Or you want to make a comment, Judge?
On that one, perhaps it's good to maybe refer to one of the decisions that have been the subject matter of discussion. The due term Middle East versus Kenya Bureau of Standards has actually indicated that that the Court of Appeal will be the final court for particular purposes. But the real final court would be still the High Court. But as you can see, the proposed bill has really washed this away. When it passes, all this will be gone. The final court will be the arbitral court. And this will speed up the decision-making, the finality of the arbitral award. So that should be consolation to the many people who are worried about the time arbitration is taking and the processes that are being invoked even to extend it. I think this has been addressed now. As when the bill passes, I think that will be the thing of the past. And as I said, this is the future that lives.
Right. I think I've quickly read the comments. I see some questions, some other comments. So allow me, participants, not to read the comments. Your comments, we have seen them. We only have 2 minutes. So allow me to just read 2 questions. Then I think I will ask my panelists to give their parting shots. There's a question from Zainul, who is asking, my question pertains to the integrity and ethical practice of arbitration process and the tier ADR mechanism. I don't know, they meant 2-tier. On a wider spectrum of ADR pertaining to mediation, though this is a forum, not on mediation, please advise. I'm not so sure I really get that question, but Pete, Patterson and Wilson, have you gotten Zainul's question? If it's in the comments, if you could see whether you can answer it, or even the judge, if you've seen it. And then my last question that I want to highlight is from Nancy. How best should an arbitrator deal with the following scenario? A claimant made an application for an arbitrator to terminate arbitral proceedings on grounds that both parties had failed to pay supplementary deposits within agreed timelines. What should be done? So there's Zainul's question and there's Nancy's Manyara's question. Patterson and Wilson, or Judge, would like to say something?
No, I'm just going through the list of questions.
All right, yes. Wilson, no, and then Patterson.
At Zainub's question about mediation should be legally enforceable. I think the only way where that happens if it's parties enter into an agreement, and then if you're going through the court and next mediation process, then it's recorded as an agreement. It can be enforced. But I think that the whole theory behind mediation is to try and parties resolve the dispute through assisted negotiation. So I'm not sure about the issue of being legally enforceable, but the outcome, if you agree, the outcome is actually enforceable. You know whether I've answered your question, Zainub.
I think Zainul is asking again. I'm asking about the legal enforceability of mediation contracts. I know this is an arbitration forum, but I think under the mediation rules, 2022 rules, and even the earlier ones, there's an enforcement mechanism where if a mediation agreement is reached, then it can be enforced under the provisions of because it can then be adopted as an order that is enforceable through the usual execution proceedings in court. I hope that is the question that you're asking, Zainul, but the mediation rules should give you the court annex mediation. If it's a court annex mediation process, they have the answer to that.
I didn't figure out how to unmute. It's when mediation is a community exercise and parties sign mediation contracts. Is that legally enforceable? Because otherwise mediation has no credence unless we go through court annex mediation.
So I think she's asking about private mediation. not a court annexed mediation. How is it enforceable? That's the question. Kindly mute once you've asked your question. Kindly, Zainul, kindly mute. I think the panelists have gotten a question. Maybe you could answer. I know this is an arbitration session, but she's asking for a private mediation and enforceability of a private mediation. How does that look like? It's not a court annexed mediation.
The
Irene.
mediation process adds up
Yes.
with a
Yes,
mediator.
Mr. Kamaara, go ahead, and then the judge can come. Yes,
Yeah,
go ahead.
mediation yields up to a mediation agreement. If it is not signed, it cannot be enforced, because if it's a community contract, the way Zainu is asking, it means parties met out there, discussed certain things and agreed on certain things, but when they went away, they did not sign the agreement. They have only maybe an oral agreement. It will have the same problems as other oral contracts, which are not in writing, and proving them in court becomes your word against mine. So I would think it will be difficult to enforce if it is not signed.
You're right. Judge, did you have anything to add?
Yes, not on this wider question on the underpinning of arbitration. Maybe
Yes.
it's good to clarify that we are in agreement with whatever the right has said. But as I said earlier, the Article 159 only talks about this being as a principle to be used by courts and tribunals. But the actual vesting, the actual underpinning is under Article 1, and I did mention that, on sovereignty. So we are in agreement. The case of Agrovet and Nyotu, I think, also made clarification on that, in that a party cannot challenge an award under section, for instance, 50 on the right of hearing without bringing a substantive petition, because you can't rely on constitutional provisions to challenge an award. You got to bring a petition so that you can actually prove violations, just like the constitutional provisions. So I believe this is adequate protection for the awards. This coming from the highest court, because there is a recent matter where I was involved, and a party, decides to go to invoke that. So I don't know what will happen.
All right. Thank you, Judge. Yes. Mm-hmm. Sorry, I didn't know I'd muted myself. I was speaking to myself. So thank you, Judge, for that. And I think Zainul's question seems to be burning. I don't think we answered it fully. She has clarified. She says this contract or agreement in mediation is signed, but it's signed under the Ismaili community mediation. If the parties are not following through, what are the enforcement mechanisms? I don't know whether, Patterson, you want to now answer with that clarification. I know for court annexed mediation is very straightforward, but what if it's private mediation signed and someone wants to enforce it?
Well, I would think that if it is signed, it is a valid contract between the parties who signed it. They can enforce it through the civil court or through their own Ismaili community system, if they have a system, a community system. But a signed contract is enforceable between or among the parties who signed it.
Thank you. Thank you so much. Thank you so much, ladies and gentlemen. I unfortunately will have to stop at that point, but let me just quickly run through the comments to acknowledge those who have made some very useful comments. I see, for example, there is Kenneth Miriti, who has talked about the importance of self-regulation to deal with ethical and integrity issues in arbitration. I think that is extremely important. There is also Mr. Ngotho, who was just confirming what Mr. Kamaara talked about, integrity and honest presentation and, personal character. And I think he actually, gives some testimony of what he's known about what has happened. And then there's Angela Nyalita, who is actually saying our image as arbitrators is not good out there. We must work very hard to redeem our image. That is true. And that's why we're having such conversations, so that we can indeed redeem our image. I would like to stop there, but before we finally stop, I would like to ask the panelists to give their parting shots before I return the floor to the C.Arb to formally close. So I could start with you, Justice Nyamu, then I go to Mr. Kamaara, and I'll end with you, Mr. Mwihuri, as your parting shots before I hand over the mic back to the organizers. Justice Nyamu, your parting shots.
I would like to thank all of the participants and everyone. Let this be the starting point of a common journey we are all involved in, and let's chip in at every stage of the reforms which, as we have seen, are required. I think we should focus more in future on the disciplinary measures that are necessary to make sure that those who, the exceptional cases that want to drag us back are not allowed to increase. We should be able to have teeth in the proposed amendments, and all will be well. No society, every society has its own bad eggs. Yes.
Okay. Kindly, if you're not talking, kindly mute. Whoever is talking other than Justice Nyamu, kindly mute. Thank you.
Yes, Irene, a moderator, I don't think we should give up because a few people are complaining. We should listen to them and make sure that in the law reforms that are currently in place, all these things are catered for. It's a matter of urgency. They are talking about research. Well, research is important for the future. But right now, let's all take part in this public participation and make our suggestions on the reforms we want in every area where we have fallen short of the expectations of our people. Thank you.
Thank you so much, Judge. Mr. Kamaara?
Like Justice Nyamu, I would say the situation is bad, but there is hope. The very fact that we are holding a seminar like this one is an indication that we recognize the enormity of the problem, the seriousness of the problem, and we are having very frank and open discussion of what it is that is wrong with us. And the next step is what do we have to do? The fact that we have those bills pending in Parliament, that conversation is in the public domain, it's a good thing because we have a movement to contribute and make suggestions that could make all the difference. Everybody must be involved. That means the courts, the practicing lawyers, and other professions who are in this space of arbitration, they must be involved in making sure that the rules that we make, they are enforced without too much trouble. Because it's one thing making very strict rules, it's another one getting our people to obey and comply with them. They comply if they come from within themselves. They are not being handed down from some authority up there. They have themselves grown them from within themselves and have set for themselves penalties that will attach to any infractions. Otherwise, we shouldn't lose hope. We still have very good people, very decent people around, and I'm sure the right thing will be done. We need this kind of seminars from time to time. There are many issues that we haven't even touched on. That issue about public-private, whether arbitration should be private or public, we need to look deeper into it and see why people choose to take their disputes to private and why it has now become important to keep it open. If we do that, will people prefer to be in the open space in court anyway and forget the court, the arbitration says? These are some of the issues you need to think through much more in the future. But so far, I'm happy that all of us have been able to contribute up to this stage, and the attendance was very good. Thank you.
Thank you so much, Senior, and over to you, Wilson.
Irene, thank you. Don't know whether my camera is on. Okay, I can't see myself, but thank you
Please,
for the
we
proposal.
can see you. Don't worry, we can see you.
I just see a QR code on the screen, but I think the discussion we're having is not an idle discussion. It's not something academic just to stimulate us intellectually. Dispute resolution is fundamental to a stable society, because in society you have very different characters and disputes will arise. And I say this because I sit in the High Court Civil Bar Bench Committee, and every so often we have meetings where the judiciary tells us the sheer volume of matters that they have to handle. It's actually quite it is an enormous load on the judiciary to handle those particular matters. And if parties lose faith in ADR, alternative disputes, whether arbitration or other means, and you say, let me go to court, you spend 6-7 years in court. What does that mean for society as a whole? For instance, as an investor, one of the things you look for is, if I put my money in a particular economy, how long will, if any dispute arises, how long will it take for me to resolve that dispute? If people lose faith in arbitration and say, let's all go to court and we spend the next 15 years over there, nobody will want to come and invest in this country. So the discussion you're having is not an idle discussion. It has real world implications. It has societal implications. And I'm happy that the Chartered Institute is taking a lead on this. And even in the state of ADR, I think it will culminate sometime later in the year, but Irene will tell us. But I think this is a good first step, and we can continue with the discussion. Thank you.
Thank you so much, Wilson. Thank you so much, participants. This is not an easy discussion to have, definitely, and I don't think it is time that we can just gloss over such discussions. These are discussions that we must have. And as one of the participants says, that our image out there is not good, but as Justice Nyamu said, is that we are not supposed to shy away. We are supposed to have these discussions. We've talked about the legal reform, way of trying to resolve this issue. We've also talked about personal character. Let it be known that you're not a person who pads time. Let it be known that you are not a person who would be compromised. Let it be known that you're not a person who will delay. Let it be known that you're not a person who will delay matters unnecessarily as an arbitrator or any or even a party as a party representative, because at the end of it all, we are all in the arbitration and ADR community. Thank you so much, participants, for your kind words. And I think some of you have said this was an excellent presentation, and I'm sure it would not have been excellent were it not for the panelists. So thank you so much, the panelists, and thank you everyone who attended. I'll hand over the mic back to C.Arb to take it over from there. Thank you.
Thank you so much, Irene. Thank you so much to our able panel. We were right to indicate at the very beginning that this is a very important conversation to have, and you have the best team to champion this conversation. I will not take a lot of your time. Mine is just to highlight a few things that have been discussed during today's event. And to assure, there's something that Justice Nyamu indicated on our role and what it is that we need to do as an institute with the judiciary. And I'd like to say that that is already something that has already started. We have signed an MOU with the Kenya Judiciary Academy. And part of that MOU is to ensure we are capacitating judges on ADR mechanisms, among other things, as well as supporting the ADR process, whether the courts or any other places. We have planned a number of activities and trainings, including webinars with the entire of the judiciary. So you'll be seeing a lot more of that coming up. And that is one of the areas that we're hoping to explore really to be part of the solution. These conversations are very important because they give us different perspectives. And that is the reason as to why we'll be holding a number of things, a number of these webinars with different stakeholders, with different perspectives, all culminating into the ADR week, which we shall host from the 17th to the 21st of November. And it is also aligned to the current state of ADR in Kenya research that we are conducting. And I know we have shared severally the questionnaires on different ADR mechanisms, whether it's on arbitration, on mediation, construction adjudication. We have a webinar. The QR code I'd shared a few minutes ago. Let me just share that again. Is on ethics. This is the questionnaire we have on ethics. Kindly just tell us what you think or give us your insights and perspective, because that is what will guide us into knowing how do we solve these challenges, how do we explore the policy framework. And just to add onto what Justice Nyamu has indicated about the ADR bills, the arbitration amendment bills, the last couple of weeks, I think about 1 week or 2 weeks before, we held a similar platform where we were debunking and demystifying these bills. And what we have done is that we have collated the discussions we had on those platforms, the feedback we've gotten from the feedback that you've shared with us, and you are preparing a memorandum that you're now going to submit as C.Arb. And some of these comments that we have had on this, we are also taking note of them. So in case you have additional comments that you'd like to share and you're yet to share, please do. There's still some bit of window, and we'll take into consideration and will incorporate in the memorandum in the comments that we are now preparing for submission to the Attorney General's office. So this is a constant conversation that we need to keep having. Kindly share with us your time, because for this research, we are asking for your time. And you'll find that these questionnaires are about 3 to 5 minutes each, or even less, but they will be very, very impactful as to how we strategize as an institution, as an industry, as a community moving forward. The other thing that I'd like to highlight is that as we progress with ensuring that we have industry-specific conversation on dispute resolution, we have this particular one in partnership with the Architectural Association of Kenya, AAK, and it's going to be held on the 24th of July, that is next week on Thursday. And we'll be looking at design, delay, and disputes, managing time-related claims on construction projects. So as you're well aware, Kenya is in its development stage. And from our research, we're realizing majority of the appointments or requests for appointments are coming from this particular area. So that is why we're taking that step to ensure that we are also creating awareness on these disputes and how we can be part of the solution, how arbitration and ADR can come in and become the dispute resolution mechanism of choice. I'd like to highlight one last thing. Q1 of this year, that is the March issue of the C.Arb journal, the C.Arb ADR journal, specifically was on ethics and integrity. So I'd like to just take your time, go to our website, download that journal, and you see some of these discussions that you're having have already been addressed in those papers. But that as it may, please also feel free to submit additional papers on any other area that you'd like us to highlight. Our journal is still up and alive, and we'll constantly create these opportunities, because I think the thought leadership is what sets us aside. It's what will give us and empower us with the requisite information to ensure we progress as an institution, as a body, as a profession. So thank you so much for the privilege of your time. See you next week. And in the interim, please let us have your feedback on anything that you'd like us to talk about next. We always take it in stride, and we'll make sure to organize another incisive and in-depth conversation. Asanteni, and enjoy the rest of your evening.